Hello, good afternoon, everyone, and a very warm welcome to Logical Talk. And obviously, we spoke about it last in the last session that we've completed 3 years of Logical Talk. And Anurag, last time when I was talking about 3 years, I was missing you because we started it together for the first time.
Yeah,
And here you're back again. Uh, so completed the whole three cycles, and thanks to all of you to help us sustain this entire effort uh, because of the continuous uh, participation, enthusiastic participation, and the kind of questions we've been getting, the kind of audience we've been getting, and a lot of feedbacks about how to improvise, what to add, what topics to choose. In fact, from the audience itself, we are also getting inputs about the speakers, and I think that's really wonderful. Thanks to all of you for making it happen, bringing us to this level. Labor laws, I think it's the only topic in the last so many years which whenever we have spoken about it, we've got the maximum registration and the participation. That made me feel that how complex the labor laws in India are, and what kind of enthusiasm, or I would say, I won't call it enthusiasm, what kind of fear we have about the labor law compliances. You do it, you do SEBI, you do RBI, you do Companies Act, you do any other laws, or DPDP also. Participation is always limited, so I'm expecting a lot of people to join in. So I'll use a couple of minutes to do our customary slide, as you all know by I'm sure by now you all know it all. So this quick introduction about ourselves, Lorbit. We are India's leading regulatory technology platform, offering global regulatory compliance management solution. Today, we are the largest team of lawyers and legal tech professionals in India who are working dedicatedly on the regulatory compliance technology. We are a team of, as we speak, a team of 119 professionals working on regulatory technology for India and global. We are serving around 650 plus entities globally, mapped 4,000 plus locations, and as we speak, there are more than 15,000 users of our GCMS platform and more than 2 lakh subscribers to our regulatory update newsletters. I'm sure all of you are also getting a regulatory update mailers. In addition to this, the solutions which you are seeing, we've also launched a few more additional solutions, which I'm sure you would be able to go and check on our website. Litigation management or legal matter management solution, enterprise risk management, and the new offering which has come from our side is IFC, internal financial control solutions, and the very recent one which is called Skebit. It's secretarial compliance and board intelligence tool, which we are recently introduced in the market. If you're already a user of our platforms, great. If you want to know anything more about any of the solutions, feel free to reach out to us. And with this, let's move to the our discussions for today. Again, I don't think I need to talk about Anurag. To those who have been attending our webinars by now already know, and I think many of you talk to Anurag more than I do, directly, indirectly. So Anurag is the founder, co-founder, and partner in By the Book Consulting. He is a chartered accountant, a great friend with more than 20 plus years of experience, assisting clients in tax, social security, immigration issues, India and globally. He has worked with the big fours in his past experiences, and has been one of the initial ones who started working on the labor codes way back in 2019, and labor laws, consulting laws, labor compliances, helping clients with the PF authority, helping clients with the trust, or migration of trust, or surrendering of the trust, has all been done by Anurag and his team of lawyers, company secretaries, chartered accountants, and Anurag is based out of Gurgaon. Welcome, Anurag.
thanks, Jayant, and congratulations on completing 3 years. And next time, hopefully, we will cover the 3 decade cycle as well.
I'm imagining, you don't have hair and I will have, whatever the
I
one,
will look
the one.
like this only. I will never age. I will never
You're
age.
not gonna change. I'm imagining myself. So, and also with us, we have Monica Agarwal. Monica is head of HR for Hindustan Times. Monica comes with more than 2 decades of experience in HR. Currently serving as in the print and research business of HT Media Limited. She joined HT way back in 2007. Um, Very rare feat. Monica nowadays completing on coming close to 2 decades in a company and growing with this organization. And she's worked with previous experience in Taj Group of Hotels, and she's somebody who is first-hand understood, experienced about the labor code, the challenges with it, and we've had some really interesting conversations when we were preparing for this webinar. And today, I would say, since we have been doing a lot of webinars on the labor codes, I think this is the fifth one in the series. Uh, we're not going to be talking on from the basics. I think while we touched a little bit about the basics, but I think in today's discussion, we are going to be talking more about the real challenges which we are facing right now, the real confusions which we are facing right now. Clients are coming back to us with anxiety, with stress. Codes have been implemented. Where are we? Where are we on the compliances? How do we start? Doing these compliances? How ready are the organization, are the business, are the government, and what kind of challenge you're facing? And I'm sure lot of questions are there in your mind. Keep chat, putting in the chat box. We've already combined a lot of list of questions which we are going to speak and touch upon in this discussion. So while we do our quick slides which we have prepared, after that let's keep it more conversational. Keep writing your queries in the mail in the chat box. Uh, so with this, let's dwell deeper into the discussion. So what we're going to cover, as I said, the chronology of events, what status of state rules, because some few states have come up with the rules, which one have come up, what is the status of them, what are what's next for the company, central versus state, which is abbreviated government, because this is also a question which has come from many clients. The wage definition, we've touched upon it in the past also. We'll quickly touch upon it. What common mistakes people are doing when interpreting this definition, because it's becoming more and more critical now. Recent modifications and a quick update on the same. Anurag, over to you.
Thanks, Jayant. So yeah, in terms of the context as Jayant laid down, so we would be covering not the basic part, because in many of the past sessions as well we have covered it. So I am assuming that many of us are now aware what labor codes is all about, how it all started. But just to give a very quick overview of the chronological set of events which has transpired over the past couple of years. And it all started in August 2019 when the Code on Wages received the presidential assent, and then September 2020, the other 3 remaining codes also received their assent, presidential assent. 21st November is, I would say, the kick-start date when all the 4 labor codes have been notified and brought into law. That means the 29 central labor legislation has effectively been repealed by this notification. Then on 30th December, we saw a framework of the draft central rules, which was released by the government for assimilating public comments. So pursuant to those entire set of exercises, 8th May is when we saw that the final central rules have been notified. Now, these are the central rules which have been notified by the Government of India. Of course, as we have been discussing in the past as well as in various other forums, labor first and foremost is a concurrent topic as per the Constitution of India. So the center will frame your baseline rules, and then the state will either adopt those rules or do the necessary modification, with the key principle at any point of time that the employees welfare will not drop below that baseline which has been set by the central framework. So 8th May was when all this has gotten notified. But pursuant to that, there are a lot of questions, a lot of queries that we are seeing amongst the company, and rightfully so, that with these notified rules, where do we stand in terms of the compliances? Where do we stand in terms of our policies and procedures? And what is the next step that an organization has to take for themselves from the compliance and the procedural perspective? At the same time, what they need to do for their set of employees as well. So that is something that we are going to be discussing today. So before we jump into the greater details of how the rule sets will be determined, what we need to understand is what is the status of state rules today, because we are talking about 36 states and union territories. So where do we stand in terms of how many states have released their rules, how many have been notified, or are there any states which are yet to even formally start at that level? So final rules, I would say, have been notified by Gujarat, Bihar, Arunachal Pradesh, and Meghalaya. And this is not something, I would say, post facto event, kind of a 21st November. After that, these were notified, but rather I would say that the by and large the state government went one step ahead when the courts received the presidential assent. Then within a couple of years, these relevant state government released their rules, got it notified, with the condition that these rules will come into picture once the main labor codes have been notified. So with the labor codes coming into picture, these rules have automatically kicked in. So states like Bihar and Gujarat, they took one step forward and basically did that. Now, whether the state governments of these region will be making some minor changes or tweaks based on the central rules is something that we'll have to wait and watch for. In terms of states like Haryana, Maharashtra, Karnataka, Punjab, Uttar Pradesh, and Andhra Pradesh, what they did was, while they would have initially post the courts receiving the presidential assent, they released their set of rules for public comments. But because there was a time lag between when the courts received the presidential assent to the date of the effective notification, in the meanwhile, a couple of things underwent change. So what these state governments have done is they've re-released their draft set of rules for public comments with the expected timelines of 40-45 days for assimilating those comments, and then another 40-45 days they will take to finalize and then notify it. So I'll give you an example, like Haryana notified it in the beginning week of May. They released this draft set of rules. So I would say in a couple of months we are going to be seeing that the Haryana may effectively notify their state rules. Likewise for Uttar Pradesh and the other region as well. Now there are many other states, because we are talking about 36 states plus union territories. So there are many other states which are yet to release their draft set of rules and go through that entire process of assimilating the public comments and then getting it notified. Well, there's one anomaly. There's one state, West Bengal, because of the obvious reasons that they never even released their draft set of rules even once. So now with the change in the government, we are expecting that those draft rules will be getting released, and there will be a kind of a quick process to getting it notified as well. So this is where we stand in terms of the where the states are. So now the big question that every company might be wondering is, where do we stand? What stand up or what position do companies need to take with the central rules getting notified? So there are, I would say, it's a mixed bag. So every company is understanding their own nuances and working out their own set of strategy. I would say most of the organization would be falling in either one of the three buckets. One is those set of organizations which were proactive, in a sense that once they got to know that 21st November, the 29 central labor legislations have been repealed, then in such a case, they started working on it. And the first step they did was to do the impact study, as was mandated by the Institute of Chartered Accountants of India as well, to start creating provision in their books for the leave encashment and gratuity part. Subsequent to that, the organizations move toward the compensation structuring aspect as well, because the wages is now a uniform definition, and there are a lot of changes that an organizations were foreseen, mainly for components like Provident Fund, ESIC, gratuity, leave encashment, statutory bonus. So what these organizations have done is basically align their compensation structure with the provisions of the code, as well as one interesting change, because there were many things which were happening. So I would say 1st April wise, many companies were thinking of rolling out this structure which is aligned with the codes, but at the same time the income tax rules were also notified from 1st April. So the organization, they took a holistic approach when they were doing their compensation structuring exercise. They said, okay, fine, let us look at it in the context of both the laws, and then basically devise our compensation structure which more or less aligns with both the set of regimes. So this is one bucket of organizations. And these organizations, after completing their comp structuring exercise, or also fast track their alignment of the policies, procedure, and the implementation part as well. More or less, I would say these organizations fall into a bracket wherein 90% of the activities are more or less completed, and now they're waiting for the state rules to get notified, so that minor tweaks here and there they will do and then formally roll it out, as far as regarding where those dependency on the state rules are to be concerned. The second set of organizations, I would say, are in a kind of a middle approach wherein they might have done the impact study, done their compensation structuring, but are now waiting for the state to getting to notify their rules and then rolling out their fresh set of policies and procedures. These are the second set of organization. The third is, I would say, laggard organizations who might be thinking that still the labor codes has not yet fully been implemented, who are under a belief that we will wait for the state rules to get notified and then we will start pushing out those changes. These are the organization who needs to be aware that first and foremost that 21st November all the 29 legislation have been repealed, and basically the new set of codes are already there. Wherever the provisions of the code do not have any dependency either on the central rules or the state rules, those rules are now effectively been implemented. So in case they miss those things, then there will be a non-compliance issue. So these organizations need to be aware about such important aspects, and accordingly start quickly working on these set of issues. So the case for them waiting are basically the state rules may carry state specific deviations. There are still some clarity needed on the rest interval spread over period for working time. Minimum wage criteria is also something that needs to be settled at state level, which is a kind of a misnomer, because while we are aware that there will be a national floor wage which is yet to be prescribed, but at present all the states will be having their own set of minimum wages which will be applicable on our organization. So there is no case for the organization to basically wait for those minimum wage criteria to be notified. Similarly, some organizations are thinking that why to align their policies right now when we know there might be some a bit of changes from the state side as well, which is again rightfully so, that there might be a duplicate exercise which might happen in that case. But again, I would say based on my experience, because we have gone through the draft set of rules, particularly I would say for recent jurisdictions like Haryana and Uttar Pradesh, we are seeing certain tweaks in those state rules as well. I will give you a very plain example, like annual health check. Annual health check, as per the central rules, they are saying that will be applicable to only organizations like having a construction activities or dock workers and so on and so forth. It is not applicable to a factory. It is not applicable to a service establishment as per the central rules. But if you look at the recent, Haryana state rules, their annual health check is something that they are going to be making applicable to each set of organization. At least that's what it says in the draft set of rules. Now, how the final rules will be, working out is something that we'll have to wait and watch. But what my intention here is that yes, there would be changes. One cannot say that blanketly that all the central rules will be automatically applicable even these state wise, or they will be just doing the cut copy paste of the central rules. Every state will be working and understanding their own nuances, understanding the kind of organization, the kind of industry that might be there in their particular state, and accordingly they would be framing those as per their own set of nuances. So that is something that the organizations need to understand. But I would say still, with the central rules being notified, at least I feel that 80 to 85% of the activities can still be completed, and then once the state rules are notified, then balance 10-15% can be covered at that point of time. At least you will not be starting from scratch, because once the state rules are notified, the compliance activity begins from that particular notification date. So it is not the case that an organization will be ready from that particular date. There would be a good gestation period that will be involved. The other important aspects is there are certain aspects on which the state rules will not be, there will be no dependency. So worker versus employees, that categorization of the employees has no relevance as far as regarding the state rules is concerned. So organizations basically have to align their data points as well as their policies procedure to understand who would be categorized as employees, who would be categorized as workers, who will be a fixed term employee, what kind of a categorization need to be done for my gig workers, platform workers, migrant population. So that is something that has to be started, because again, the state's rules will not provide that much amount of clarity. That clarity is already there in the relevant codes. Secondly, regarding the wage and the CTC audit, now that we have a good amount of clarity on the wages, there is nothing which prohibits an organization for not understanding how the wages definition will fit into their current compensation stream, and whether there is effectively a need for designing a new compensation structure. So that is also something that should not have any dependency on the state rules. Uh, Another important aspect is around the forming of certain committees like the grievance committee, safety committee, and works committee. Again, most of the mechanism has been laid down in the provisions of the code and the rules. Those limits have been specified by them. So, grievance committee will be applicable for any organization having 20 or more workers. Works committee will applicable once I have 100 plus more workers. So all those limits are floating from the provisions of the code itself. So again, not much dependency on the state rules except for a few items here or there. But this is also something that the organizations can go ahead and start forming these committees. Who will be the chairman? What will be the representation from the worker side? What will be the representation from the employer side? There would be a representation from the women employees as well. So that is also something that they need to keep in mind. So in terms of the appropriate government, I would personally always say that this is one single definition which will holds a lot of value in terms of understanding by an organization as to which rule sets will be applicable to them. And we need to understand that while the government's intention has always been to keep a uniform definition, that cannot have a blanket formula for each of the codes. Reason for that is while the definition of the appropriate government has been defined in each of the labor codes, in one code in particular, that definition carries a bit of a variation. As a result of which, there could be a hybrid situation wherein for three labor codes, which is IR code, industrial relation code, OSH code, as well as code on wages, my appropriate government as an organization could be the central government, whereas for the other streams I might be having a state government or vice versa as well. So those situations could be there. So what we need to first of all understand is how the appropriate government has been defined. So appropriate government will be a central government in case of organizations which are coming from the streams like railways, including metro services, mines, oil fields, major ports, air transport. Typically, something which has always been considered or was considered a domain of the government. Telecommunication, banking, or insurance companies again will fall under the purview of the central. So central government will be the appropriate government for this, and accordingly the central rules will be applicable for such set of organizations. Even our PSUs having more than 51% of the central holding, and they will stay central even if this percentage falls further. Similarly, any bodies which has been formed under the Central Act like RBI Act and so on and so forth, they will continue to be controlled by the central rules. Similarly, if these set of organizations engage any contractor, then again the contractor will also be required to comply with the central rules as well. So this is one important aspect that the contractor organizations will also have to keep in mind. As far as regarding the state is concerned, so any establishment which is not governed by the central government will automatically get covered under the state government. However, in one caveat there is in terms of the organizations wherein they might be having divisions in multiple states. So any company which may be having their branches set up in Karnataka, Bombay, any other region having multi-state presence, then in such a case the appropriate government will be central government, and that is one big variation which has come around only in the code on social security. Otherwise, in the other remaining codes, my state government will be by appropriate government. So by and large, I would say the common stream would be that for most of the organization, and I mean most of them apart from these organizations that I earlier stated, for most of the organizations, the state government will be the appropriate government, and accordingly the state rules will be applicable as far as regarding the three codes, which is IR code, OHS code, and the COW code is concerned. Whilst for cause, which is code on social security, if I have a multi-state presence, then for me the appropriate government will be central government. If I have a single state presence, which means my establishment presence is confined to only one state, then in such a case, the state government will be the appropriate government. So this is one clarity that all the organizations have to done, because based on this classification, based on this determination, they will have to work out there which rules will be applicable on them.
Now, Anurag, this creates a lot of further ambiguity because one the when you said the organization covered under central government.
Hmm.
Now you said contractors engage in the above establishment. Now, if I talk about the entire infra sector per se, they are somewhere or the other engaged with the set of organizations which you have mentioned, mentioned above, uh, which itself is a very large chunk. And then you said,
Hmm.
if you're engaged in multiple states now, most of any large enterprise is multi-state. So,
Hmm.
are you facing any kind of a challenge when organizations are trying to define whether they are these laws are
Absolutely, it will be
already
a
applicable?
challenge, because I'll tell you, Jen, because while the central rules have been notified, so for a single organizations, there might be again a hybrid scheme, but whereas for central rules will be applicable on them, provided they have a multi-state presence, then I have to, or the organization will have to also have to ensure that they have started complying with the central rules, because that has got notified. While for the other set of rules, for the other three labor codes, they may have to wait and watch. But I would say again, as I was talking earlier, we don't have to wait that much, in a sense that we can start those preparatory activities sitting today. And then once the state rules are notified, and in case there are some tweaks here and there, then we true it up and then accordingly roll out the policy. So while we are working with a large set of organizations like listed companies, unlisted, or MNCs, or even MSME enterprises as well, what we are saying is, let's not wait, because there might be fillers that an organizations might be getting, that okay, let's wait and watch, and it is always a comforting sense that ठीक है, अभी whenever the state rules are rolled out, then we will put our efforts in. But I would say that would be a wrong notion in that sense, because I feel that we can start with those preparatory activities. We know the framework, we know what is the government intention, we know what is the baseline that has been set up by the government. So we'll start working on that, and in case the state government decides to push those limits further, then there will be a minor tweaks which will be involved. Of course, the final set of policies can be released, and many organizations can do so. Make it a version 1 policy, and then once the state rules are rolled out, they create a version 2 policies around that. These are the, I mean, different permutation combination that an organization will have to go through.
So, Anurag, now this opens another can of worms. I have
Hmm.
not complied with the labor codes today, but if I look at the definition, I fall into labor codes now. What happened to me? I've already missed on to 6 7 months being non-compliant. What are the are there any repercussions on the organization if in such scenario, or they need corrective action then they're supposed to take?
See, as far as regarding compliances is concerned, first and foremost, ignorance can never be your defense. You cannot say that I wasn't aware, or the government didn't give a proper amount of clarity around that. So that is not a defense. I would say my compliance, or whatever provisions have been enacted by the government, which are called the fundamental legislative part. So we cannot say that effective 21st November we failed to comply with that. So organizations have to work around it. Now the key thing is about the enforcement part. How soon the government's authorities will start working on it, and then they start issuing the notices also, so and so forth. I believe there will be a kind of a relaxation attitude typically advocated by the government, and they may also come out with some kind of a voluntary compliance scheme as well. That wherever some non-compliance has been done, then the authorities or the companies will be allowed some bit of time to
It's
do those
4 o'clock.
disclosures. I'll give you again a very plain example, and this is again a question that I have been receiving from many companies. We know 21st November it has been notified. There were instances wherein companies were processing the gratuity for their employees. They processed the gratuity based on their normal basic pay, because that was the definition of wages under the erstwhile Payment of Gratuity Act. Now the big question that I've been facing is, now with the wages coming into impact, first and foremost is is the November the timeline when the wages has been put into action or been implemented? The answer is yes. So today down the line, if somebody is remitting gratuity to their eligible employees, should they pay it on the definition of the wages, or should they stick to the older definition, which has been again clarified by the government in one of their FAQs as well. So the main point is, even if they have processed the gratuity, now they have two to three approaches. One is they don't do anything. They say, okay, fine, we have processed it, let's be it. But then they would be sitting on a non-compliance. And again, the trigger could be one of the employees approaching the regulators and saying that I have been shortchanged and there's been a lesser amount of gratuity which has been paid. The second is you again approach the relevant employees and tell them that yes, because of the change in regulation, there was a short amount which was paid, and now we are releasing this extra amount. The third trigger could be at the time of the audit, it all gets triggered in case any compliance audit is done by the regulator. Then in such a case, they would say, why didn't you comply? And you cannot say at that point of time, oh no, there was a lot of confusion, we were not aware. You cannot use that here as a defense strategy, because government through one of their FAQs have themselves clarified that it is notified effectively November 21st. So that is something that organization has to take be cognizant about when they are, taking those positions as to how the compliances has to be met.
Monica, what are your thoughts, opinions on this?
So it's interesting discussion. I'm actually enjoying it. I hope the participants are also enjoying it in equal intensity as I am. So see, what we have done is there were certain things, and I completely agree when Anurag says that certain things are clear and they need not really wait for a state to notify that, and certain things are still to be notified by the state. But financial modeling was something that we have done. So we did it in Q3 itself of the last financial year, because gratuity was something which was very sensitive, and we had started paying. Rather, at the time when we were not very clear about the wage restructuring, we still just picked up the CTC, did a 50% of that and calculated gratuity, because it is also given that whenever you are in confusion, the thumb rule is whatever is beneficial for the employee, you go ahead and do that, right? And that is what we have already done. So financial modeling is something that we have done. Gratuity, leave encashment, also to some extent we have started. And on this, I would want to, in case we have HR people joined already as the audience, I would say that anything which is to do with the categorization of employees, which is, say, if the person is a worker or a fixed term employee, manager, supervisor, so that categorization should be must. I'm not sure if that will be much tweaked by the state. I don't think it will be. The definitions are quite clear. So that is one thing that they should quickly do. And basis that, whatever is the financial implication, they should, even the leave encashment, they should start working on that. And something that they probably can hold back as of now can be maybe the physical registers or the digital registers that they have, some compliance formats that they have. So this is how I see it, that the way forward on this, wherever there is confusion.
Right. Thank you.
Yep.
I think, there is already one question in the chat box. What about companies that register in Maharashtra and have their plants in other states, and workers are working for them in different states? So the two scenarios I'm assuming, one is obviously they have plants in multiple states, and then there are possibly workers who could be sales employees and deployed in the other states where they do not have a S&D registration. That's what I'm assuming, or even if they may have a S&D registration. So, what's the take?
Well, I'm sure their divisions or whatever it is operating, they might have registered because they have a presence of the employees. But at the same time, the local state tax regime would be applicable in terms of PTs and labor welfare fund and so on and so forth. So I would say for such category of establishments, as far as regarding the code on social security is concerned, there will be a central government which will be the appropriate government. Whilst for the other three regimes, the state government will be applicable for the other three labor code regimes. Yeah.
Not only SNE, I think the Factories Act also, they would be registered. So they
Right.
have to follow. Yeah.
Absolutely,
Yeah.
absolutely.
Yeah.
So now that main argument has been, we have tried to understand which state rules and all those will be applicable. I want to pivot a little to this wages definition. The reason for that is, again, today down the line, one may feel that there's a lot of clarity on this issue. Organizations may have done the compensation structuring, but still, again, based on the failures that we are getting whilst working with the companies, whilst working with their HR heads and the compliance, team, I am getting a failure that yes, there might be something which an organization might be missing. But before that, just to kind of a refresher of what the wages definition is all about. So wages definition, again, is a uniform definition across all the four labor codes. It means all the remuneration which is being paid by an organization to its employees, including basic pay, DNS, and retaining allowance. So these are what I call as the operative core of the term wages. And then there are certain 11 components which have been specifically carved out under this. And these are basically your usual suspects like your HRA, conveyance, overtime, employer contribution to PF. I think there is some typo on the ESI part. It's not ESI, but rather it would be NPS contributions. And then there is a start bonus, commission, gratuity, and on so and so forth. So all this is something that has been carved out as exclusion, but at the same time there is a conditional inclusion which gets kicked in, provided or in cases where my exclusion baskets gets bloated to a certain extent. So once it gets crosses that 50% threshold limit, then that differential or the delta amount gets added back and added back to the definition of the wages. So that is what the precise definition is all about. But there was a lot of queries when this initial definition came into picture, and these queries I've been facing not from 2025, rather from 2019, because the core concept of the wages hasn't undergone change. And it's interesting to see, because what has government tried to do is provide a, I would say, a remixed version of the wages, because in each of the past respective labor code legislation, we're talking about 29 labor legislation, there used to be a different definition of wages, there used to be a different interpretation. So having looked at those definitions, I would say the government has tried to arrive at a good balance as to how it should be construed. Because they've tried to mix the ESIC definition with the payment of wages, with the minimum wages legislation, and then try to arrive at this particular stream of definition. So one thing is very much clear. Yes, it is uniform across all the four labor codes, but it has to be applied in a very, very careful manner, because I would say there are certain aspects that one needs to take care of when you do that planning and when you do that compensation structuring. At the same time, whilst looking at the definition, one also has to refer to the FAQs which has been released by the government of India from time to time. Do have a look at those definitions, because the interpretation that you might be arriving after reading the definition of the wages might get a little bit different once you have gone through the FAQs. At the same time, and this is one big caveat that I always say, is FAQs is never binding. So whenever there's a conflict between the provisions of the code and the FAQ, the provisions of the code will always prevail. You cannot say that I took this position based on the FAQs, and this is one strong disclaimer that they put themselves in their FAQs as well. So FAQs, you can rely on it to a certain extent, but you should not rely on it on a blind basis. So arrive at that, do that little interpretation of the definition of the wages, have a look at the FAQs. In case you see that yes, there is a harmonious interpretation, at the same time always say this concept of the wages is nothing new except for the conditional inclusion part. So do refer back to the old laws as well. Do refer back to the old judicial rulings and see what was the intention when a certain allowances were being provided. Put it simply, like if I am providing a conveyance allowance, whether it needs to be included, excluded, but what exactly does the government mean when they said that what conveyance allowance covers? What does the stat bonus cover effectively? So there are multiple judicial rulings which may agree with our contention or our view, and then there are the rulings which might not. So again, we have to marry all these different interpretation and then arrive at a reasonable view. Again, taking a cue from what Monica said, between two differing views, the one view which is always beneficial for the employee, that is one thing that we have to take, and that is one big thumb rule that we always take whenever we are advising our clients as well. So this is what I've compiled as a kind of a five biggest mistakes, or I would say five biggest misconceptions that the companies might be having. They might be under the impression that they would have completed their wage structuring exercise, but just as a kind of a filler as to what we have experienced as a consultant when we are having this conversation with the client. Some of these mistakes were highlighted when we were discussing with them, because they said, okay, fine, we have done it, can you have a relook at our structure? And then we noticed that yes, there were certain anomalies which were not aligning with the provisions of the code. So one is ignoring the 50% add back, and I'll tell you the reason for that is the formula, the logic that one has to work out when they are working out this definition of the wages. And because your payroll systems also have to be implemented accordingly with that logic, is by seeing or ensuring that your exclusion basket is not crossing that 50% threshold. Because I think one of the thumb rules that companies have been taking is, okay, fine, government has given us a good amount of exclusion, let's bloat up that basket. So I've seen companies who would have said, what we have done, Anurag, is we have increased our HRA. We have increased the HRA to 80%. We have gone to the extent of 85%. My thought process around it is, you can extend it to 50%, 60%, 50%, I think is the reasonable limit. You can also extend it to 60% to a certain threshold, because if somebody is living in a metro city, the allowances or the rental amount is so huge that 60% is still to a certain extent justified. But if you bloat it up to 80%, first and foremost, that question of reasonableness is something that can be questioned later by the regulator, and it has been questioned in the past as well. As far as regarding certain contributions like PF in ESIC, we have seen regulators questioning that why you must have inserted that particular allowance, but what was the logic, what was the reasoning, as well as what is the amount that you are giving, what is the sound logic behind it. So it has to pass that basic smell test as well. And the second important factor that I was seeing was, while they have increased their exclusion basket, but they never put into that logic framework that in case my exclusion is beyond that 50% threshold, that differing amount has to be added back. So that logic is sometimes that I've seen while working on the spreadsheets with the client, that they haven't added that thing, because that it will have to be added back. And if you don't do that, you are again falling in a non-compliant stream. One of your defense could be that I'm contributing on 50%, so what? So at least I'm complying, but that is not a compliance. The government is saying that your exclusion, if it crosses that 50% threshold, will be added back. So that means one of your defense could be, at least I'm contributing 50%, but the government has never said that you have to contribute a bare if you are doing a 50% contribution, then you are totally compliant. They've never said that in the code. What they are saying is, if your exclusion basket is more than 50%, let's suppose my exclusion is coming to 60%, my inclusion is 40%, then that extra 10% will be added back. So there will be no defense for all of us wherein the exclusion basket is bloated to that extent. The second mistake that I'm seeing companies commit at the time of structuring or at the time of the interpretation is to do a very narrow interpretation of the term of wages. So wages doesn't only means the three components that I was showing in the previous slide, which is basic plus retaining allowance plus the DNS allowance, but it encompasses all the remuneration. So one view that I have seen many organizations say, okay, this is my three components that will be forming, other will be forming automatically part of exclusion. That is not the case, because sitting underneath all this would be a components like other allowance, special allowance. I've seen some companies provide software allowance and somewhere around that as well. So I've seen those things, but again, those are balancing figure at the end of the day. So that also forms part of their remuneration kitty as well. So that is something that organization has to be aware about, that just incorporating these three components will not make you compliant with the definition of wages. The third mistake, and this is again not surprising in a sense, but at the same time very, very common, very, I would say almost in 80 to 90% organizations that I've been discussing with has undergone this thing, wherein wherever you're issuing an employment letter to your employees, you could have made a variable bonus as a part of your.
Looks like we lost Anurag. Let's wait for our 2 seconds.
Mhm.
Monica, you want to add something in the meantime? By the time we bring him back.
Yeah.
Yeah.
Yeah,
Hello,
Anurag.
Okay,
hello.
so Anurag is back.
Yeah.
There, you're back.
Yeah, yeah. So, so what I was saying was, I think I was talking about this forgetting the variable and contractual pay part was that this is again one of the misnomer that many organizations might be having is that when you structure the CTC of your organization, many organizations say this is your CTC which includes your variable bonus as well. Nothing wrong with that. But the minute I say that my variable bonus is not variable but rather committed amount that I'm paying to an employee, then there could be a potential non-compliance sitting in your hands. The reason for that is the minute I'm saying this bonus is committed, this is not attached to any condition, this is not attached to any performance by the individual or performance by the organization, then that bonus is nothing but a wages. It forms part of the wages. And this is one interesting observation that I saw in representing the case of one of the companies in a PF matter, wherein the authorities categorically said that Anurag, wherever you are committing a payment and that payment is fixed by nature, and in case it is not falling in any exclusion criteria, then in such a case we will include it. So if you are making variable bonus as a part of your CTC, but that variable bonus is per se not a variable but a committed bonus, then in such a case it will be added back to the definition of the wages. The
But
second important part.
no, but this is an interesting case. How do you how do you define? How do you justify? Is it a some kind of a policy, some kind of you need to have along with it, or
See,
what
I'll
would
tell
a
you
regulator take? Hmm.
how we used to find it out is by having a look at the employees handbook. Many organizations have framed their employees handbook, or while at the time of looking at the employment contract we saw that there was no contingency attached around that payment. So when we saw that reading of that particular employment contract, we immediately asked that you have included it as a variable bonus, but do you actually pay it later? So they say we make it a part of our payroll process. We pay it on a monthly basis, and again examining the payroll register, salary register, we saw those amounts are varying. So this was one. So that is a trigger that happens because even if today down the line the regulators comes asking for compliance audit, they would have a look at your employment contract, they would have a look at your policies, they would have a look at your wage registers. The minute they have a look at your 12 monthly wage register, they will see this particular amount appearing on a monthly basis. In which case the biggest question is, if it is variable by nature, first of all, why it is not being paid on a one time kind of a thing. Secondly, what is the what is the conditions attached to it, because from day one you start paying those bonus. Even in case of a new joiners as well, I've seen that the payroll registers contain that amount right from the first day when their payroll gets processed. That amount was appearing, and that is a potential trigger, because then you're not paying them a bonus, this is nothing but a wages as well. And this I have seen again in while carrying representation for PF matter or ESIC matter, and the regulators have been very much clear by saying that we don't construe it as a bonus. There's no contingency attached around it. It is a kind of a wages. The second important distinction I would like to draw here is around the stat bonus as well. So I've seen many organizations paying stat bonus, making it a part of their CTC, and saying that okay, this is a stat bonus we are paying under the payment of bonus act. Fine, nothing wrong with it. But if we, what I always say is the devil is in the fine print. So if you look at the fine print of the wages definition, they've said stat bonus to the extent it doesn't form part of your offer or contract of the employment. So minute I make the stat bonus as a part of my CTC, it can be or a view can be taken that it doesn't form part of my exclusion. The stat bonus is something which is dependent upon certain factors. So you need to have an allocable surplus, or even in the case of a loss-making organization, that stat bonus has to be paid. That stat bonus in the range of 8.33% to 20%. The stat bonus has to be paid after the end of the fiscal year. Typically, there is a 6 monthly cycle after which it is paid. Again, if it forms recurring part of your every payroll register, then the question can be asked by the compliance auditor, who can say by this amount appearing on a monthly basis. You may build an argument that fine, I am at least complying with the law under the specified chapter of Code on Social Security. But then, if somebody has a close look at the definition of the wages, it simply says stat bonus to the extent it doesn't form part of your offer of employment. To the extent it doesn't form part. The minute it forms part, then in such a case that the authorities can say it doesn't form part of my exclusion, it goes into the inclusion criteria. So that is another thing that I have highlighted to our clients. Another area that I've seen companies, not aligning with the definition of the wages is having that singular formula for applying the wages. The important aspect is that for deriving my PF, my dependency will be on wages. For deriving the wages, my dependency will be on PF. So there will be a kind of a circular reference which will be happening. Again, for ESIC as well, the dependency will be on deriving the definition of wages. But for deriving the wages as well, the dependency can be on the ESIC aspect as well. Similarly, for gratuity and the retrenchment, one has to be careful that gratuity payable at the time of the termination, retrenchment benefits payable at the time of the termination doesn't come into that 50% exclusion criteria. And this is another important point that one has to keep in mind, that when we are arriving at that 50% exclusion list, there are two sets of components, which is gratuity payable on termination and retrenchment benefits that doesn't form part of that 50%. So companies can pay this amount at the same time not triggering that 50% conditional inclusion clause. So these are the aspects. And again, it all depends upon how you have interpreted your definition of wages, how you have built the logic around it, and then how you have put that logic inside your payroll process. So that is something that needs to be taken care of. Last but not the least is
just taking you back to point number 3 again. There are a couple of questions. Let's try and address it right now. So you're saying is how is joining bonus treated?
So joining bonus, referral bonus, I would say occasional bonus that an organization might be giving, star performer bonus. These are all one-time payments. These are conditional upon, prescribing certain or fulfilling certain conditions. These time payments are what I call as incentive payments. They are latched to certain conditions. They are not being paid to all the employees, and they are not being paid uniformly. In which case they qualify, they don't even form part of your remuneration. If you ask me in one word, they do not form part of remuneration. And that is something that though the government has specified in their FAQs as well, that they will not form part of my remuneration. But I think the logic was there in the older laws as well, in the earlier erstwhile regime as well. They've never considered the contingent payment as a part of wages. So the logic was there. I think the government has fortified that logic by saying that it makes no sense to include this part because they are variable, because these are one-time payments. And from the compliance side as well, because I'll tell you, 2019 when all these laws came into picture, there was a lot of confusion as to how it will need to be interpreted, how the things will go about. And bonus was one big ticket item, because the way the wages was sounding at that point of time, interpretation was that even the bonus have to be included. And that's why it became a headache for compliance guys like us to understand that today down the line my wages might be running at this wavelength, and then suddenly my bonus will increase, and then suddenly my wages will be on a higher stream. Then in such a case, how the compliance will work out. So that was the biggest headache. But I think the government logic is truly correct in that sense, because in the erstwhile regime as well, they never included those one-time payments.
So Anurag, everything which is say a notice period buyout, a joining bonus, spot bonus, we have something called Journalist of the Month award, which is a monetary award. So all these things, I'm assuming, will not be forming part of the wages.
It will not be forming part of remuneration. Yeah.
Okay. But this is interesting on the variable pay. So if there is a proper laid down policy whereby we say that, okay, this is the variable pay which is mentioned in the CTC, it is linked with the organization performance, individual performance, and this is the process, how the individual performance will be assessed, or the organization performance, which is linked with say a revenue or a EBITDA achievement. So in case there's a proper laid down policy and the payments are done either biannual or annual, based on that policy, and in case you've not achieved any of the targets, then the variable money is forfeited. So that qualifies, I think, outside
absolutely. Yeah, okay. In fact, I forgot one example. ESOP is another thing that many startups, many established and many listed companies also provide ESOPs. So on ESOPs as well, when the law first initially came, we were wondering whether the ESOPs can be treated as benefit in kind, because there is a benefit in kind valuation as well that they have prescribed. So that is also something that we were considering, but then thankfully government has clarified that even ESOP basket is something that will not be considered for valuation of the remuneration
Yeah.
thing.
What about the perks? So, in case we provide, say, a club membership, okay, we reimburse the club membership, or maybe a company provided car or a driver. So, how these things are treated?
See, I'll tell you on certain aspects, there is still multifold views which are going around. So I'll give an example like uh, education allowance. Now, why has education allowance suddenly come into picture is because earlier the limits under the Income Tax Act was that you used to get a education allowance 100 rupees per month per child up to two children. So a very, very nominal amount. Now that has been increased as per the new income tax rules. Now suddenly that has gone to 3,000 rupees per child. So 3,000 into 12, 36,000. If I multiple child, 72,000 is the plain blanket exemption that companies can provide to their employees based on the declaration. You don't need to submit any proofs. You don't need to submit any receipts of the school. So many organizations, in fact, I was talking to a couple of companies and they were saying that now the organizations employees are also getting aware. So they've started approaching that why are you not giving me education allowance? It's a tax free, at least under the old regime. So at least we can look into it. So they then the question came whether that education allowance will form part of our wages basket or not. I would say the answer is it will form part of inclusion basket. The
Okay.
reason for that is under which of the criteria I would be putting this particular education allowance. It is not overtime, it is not HRA, it is not something that I'm contributing towards the Provident and the pension fund. It is not a sum being paid to defray expenditure incurred during the course of employment. So automatically, if it is not coming under any exclusion, then the concept is it will form part of inclusion only. The second thing is around the club facilities. So club facilities again very very personal by nature. Income tax rules have treated as a tax-free perk provided certain conditions are getting satisfied. You provided uniformly to
Right.
all the employees. That facilities we provided. But again, I would say it is more personal by nature because it is related to the health of a employee. It is forming part of our CTC. So one is if the company is making a direct payment to the club, then can it be treated as a benefit in kind, right? The second aspect is if the company is reimbursing it to their employees, employees submit their bills, they get a reimbursement. Then under which criteria or exclusion it could come? Can it be treated as an amenity and benefit? I would say there are multiple views around it. Again, formal clarity is needed from the government on components like club facility because there are multiple views. I my personal view, if you ask me, is it's a personal benefit by nature because while the organization may like to say that it is a part of a a progressive health kind of facility that we are providing to employees, it is more akin to a personal unless until you can justify that that club facility is being used for business purposes. So many companies provided a club membership, which is used for networking, which is purely for business purposes. Then in such a case, you can club it into the any sum being paid to defray expenditure, unless until you have justifiable reason. But if it is purely and purely personal by nature, I would take a conservative view and make it a part of the inclusion basket. At least that's what my personal view is. Of course, I think based on the representation by companies, we might see some formal clarity from the government on this. Similarly, for car lease as well, there are again multiple views that can it be a part of the conveyance allowance or the traveling concession being provided by the employer, or rather it is a benefit in kind because that is how your perquisite valuation also works out under the Income Tax Act. So there are multifold views around the car lease part as well, which one needs to take into consideration.
And do you think the government will come out with more FAQs on this?
I'm sure because it's a very, very, evolving kind of a framework. So I would say that the government has been very, very proactive in that sense. That whenever they have released any legislation, and not only specific to PF, but rather in income tax rules as well. Whenever new legislation comes, they quickly release the FAQ statement. Most of the issues get resolved then and there only. But there are many issues which have a practical side to it. So it is only when we start practically executing it that those questions come into our mind, and that is where the owners as a consultant or owners as an being a part of the HR fraternity, is to pose those questions with the right, at a right forum, and seek remedies or seek, clarification from the government on this.
Right. And when you say right forum, what do you really mean by that? So as an employer, where can I put up these queries, which can be very specific to my industry?
See, for your industry, I would say there might be some trade kind of a forum. So, like, I'll give you an example for IT and ITS. There's NASCOM is a forum
Hmm.
wherein they can address their, concerns,
Hmm.
and the NASCOM takes it on a
Okay.
consolidated basis with the regulator. Similarly, I'm sure you, as a journalist fraternity, you would also be having some kind of a forum, trade forum, in which you can basically, take these concerns, and they will then seek remedy, or being a part of the prestigious organizations like yours as well, you can straight away approach the Ministry of Labor and Employment and seek, responses to those queries.
Okay. Sure. Thank you so much. Yeah. Jayant, am I taking the time out from the participants? I'm so sorry. Yes.
No, no. In fact, you are in fact addressing some of the queries which we already received in
Yes,
the
absolutely.
Q&A. Yeah.
Okay. Okay.
So we're
Thanks.
going very relevant.
Yeah. So last mistake, or last, kind of a misnomer that I'm seeing companies do it. So initially, Jen, what had happened was, as I was telling you earlier, that December 2025, the government released the draft rules, and interestingly, in one of the clauses of the draft rules specific to code on social security, they said that for determining gratuity, the wages will be construed like this. And in it, they said that there are certain carve outs like ESOP, scratch allowance, telephone, internet, meal vouchers. So, and I was telling to my, colleagues, as well as, and I was speaking to a couple of regulators, that you want to keep a uniform definition of wages, and then you do a carve out like this in the rules. Then how do you understand, or basically, do that differentiation, or do that interpretation? So I think they have addressed it in the final set of rules. They have done away with that thing, but still, I believe there are many organizations who might still be going with those draft rule mindset and thinking that, those certain components might be exclusion. So one thing one needs to be wary of is that draft rules is no longer in picture. Whenever you are doing that compliance, and whenever you are, pulling out your policies or framing them, have a look at the final notified rules. Stop referring to the draft rules, because they might, create some other impression of how what you need to follow. With this, I would say there have been some interesting notification and circulars, and I just wanted to put this slide, because of the reason being, I would say, as a consultant, it's a very, very dynamic environment right now. So every few weeks, or rather, I would say on every week, and I have to keep refreshing my relevant knowledge portal as well, that the government is releasing some changes or the other. And it is not only the central government, but I would say the state government is equally working hard to keep releasing something or the other. So one first of all have to be on their feet, understand what these changes which are being released by the government and how it will be impacting, the organization and its employees. So couple of important notification has come after the central rules have been notified. One is that the PF wage ceiling, and again this was a kind of, I would say, a missed opportunity. Might be so, might be my impression right now, or it might be so that the government might be, coming out with a new set of notification. But as of now, the wage ceiling for PF has been kept at 15,000. I know there were a little bit amount of murmurs wherein there was that it may increase to 25,000, 30,000. As of now, they have kept it at 15,000 only. Similarly, as far as regarding the ESIC aspect is concerned, again, this is a kind of a clarity. It was already there under the erstwhile regime as well, that wherever a person crosses a threshold limit, so under the ESIC, there is a threshold limit of 21,000. And again, we will have to wait and see whether that limit remains the same or they may change. With the kind of no change that has been brought in PF, so we are anticipating that the ESI limit will also continue to remain the same. But wherever an employee crosses that threshold limit because of increment or whatsoever reason, then they will have to step out of that ESI umbrella. Now, one is what there's a concept of contribution period in ASIC, and that contribution period is broken into two parts in a fiscal year, which is from April to September and then October to March. So let's suppose a person gets covered under the ASIC regime in the month of April, and then suddenly there is a wage increase. He crosses the threshold limit of 21,000. So the organization should always be careful that they do not exclude that person out of that ESIC immediately once he attains. they have to continue that contribution for that particular contribution period. So in case he doesn't qualify for the threshold limit, for April, May till September, that contribution has to go, and then for the next contribution period, that contribution can stop. So this is again a kind of thing that anyways many companies were following under the erstwhile regime, but has been fortified, or rather I would say reiterated by the government. Similarly, the interest on dues. So wherever those interest on dues were there under the Code on Social Security, that has been notified as 12% per annum. So again, the same rate, and this has been made effective from 21st November. So again, not much change. One interesting change, and this is for the organizations who are having a exempted trust. So these are those set of organizations who are not contributing their PF towards the EPFO, but rather having their own private PF trust. The inspection charges earlier was 0.18%. That has been increased almost, I would say, 2 times to 0.35%. So that is a big change, because that will increase the outflow for the organizations having their own PF trust, because that is something that you don't do a recovery from the employee, but rather this is a cash out situation for the relevant employer organization. For EDLI, again, for exempted EDLI, so many organizations take that EDLI exemption as well, because they might be having their own insurance scheme in place, which is at least similar or better than what the EDLI scheme currently provides. Then in such a case, the inspection charges has been kept at 0.005%. But what has interesting been done is there was a minimum charges. So that minimum charges has gone up substantially. That minimum charges, it's like a minimum plate charges that we, whenever we deploy a caterer. So that minimum charges earlier was 5 rupees for PF trust, and then only rupee 1 for EDLI. That has increased from 5 rupees to 8,750, and from rupee 1 to 1,250. So this is the minimum charges, inspection charges, that an organization will have to pay. So again, I think the intention of the government is, yeah,
this amount is per employee.
Yeah. This contribution is per employee. Yeah. So this is basically 0.35% is of the wages. So in case you have 10 employees having that wages, it will be total wages into 0.35%. That is how the calculation methodology works, but subject to a minimum of 8750. I think it will be a consolidated amount, not a per employee, because then it will be sounding a little absurd, because 8,750 per employee would be a tad bit harsh. I think it will be a consolidated charges that a company will have to pay on a minimum basis.
Okay. Yeah. Then it's then something which is not.
Yeah.
And any company which is having their own trust, I don't think that's a very sizable amount for any for anyone.
In fact, I am seeing many companies, and in fact, we are working with a lot of companies on who want to now surrender their PF trust and then move their entire regime to EPFO, because the EPFO facilities are getting better day by day. So those kind of things are also happening. And even if you look at Code on Social Security, they are also, their emphasis on creation of trust, wherein you have a minimum set of 500 employees or more. So the smaller trust is something that we are seeing that many organizations might be liquidating and then transferring the regime to EPFO. Similarly, on a separate note, the worker reskilling fund has also been created by this notification, and it came in a similar date as the central codes were notified. So the worker reskilling fund is there. The concept of the worker reskilling fund is that wherever an organization retrenches their employees, so they have to transfer a certain portion, which is at least 15 days of pay. 15 days of wages has to be transferred to this particular fund, the particulars of which will be posted in the the website by the government, and then this amount has to be transferred to those particular fund. I'm sure there would be some disclosure requirement as well, and then the government within the 45 days will be transferring this amount to the respective category of retrenched employee. So that is the entire process. So government will be acting more like a bridge. So I think the thought process is the government might not be having a faith on the organization to pay this amount directly to the employee. That's why they might be acting as a facilitator to ensure that every employee gets paid this amount on account of a retrenchment. And last but not the least is around the rest interval. So there was this was again expected, because this was not appearing in the provisions of the code. So in one of the notifications, the central government has notified that what is the rest interval. So after every 5 years, 5 hours of continuous work, there will be a rest interval of at least half an hour. At least that is what the central government has prescribed. So organizations who will need to follow this central rules will have to comply with this. Again, I think mostly the state government will might also follow the same suit, and this interval may remain the same. Uh, One interesting change that I just wanted to highlight our audience is around that recently Bihar has gone one step ahead. I know Bihar is moving a little faster than other states. They have they went one step ahead and in fact repealed the Shops and Establishment Act completely by saying that because most of the provisions are already covered in the OSH code, so they've said that the Shops and Establishment Act has hereby been repealed. Now this is one thing because as we have been discussing in the past as well, Jen, that there's an overlap between what the code says and what the relevant state shops and establishment says. So in that situation, which one should follow? And I think in one of the FAQs, they plainly assert that again the principle of the harmonious interpretation would come into picture, and wherever those views are more beneficial for the employee, those positions are more beneficial, organization need to take that particular position. But we'll have to, and it will be interesting to see whether the states will follow, other states will follow the same suit to what Bihar has done and start repealing their shops and establishment. My guess is not so much because some of the states are very much reliant on the shops and establishment regime for their revenue stream as well as for the reporting and disclosure scheme. So it might not happen immediately, but this is something that we may have to wait and watch.
But under considering, if I look at the law and the state politics and the coastal politics together, I'm saying is if a BJP ruled state has taken that decision, I'm sure there's a kind of an indication that others may also follow because, as you rightly said, there is a bit of ambiguity, and I think there was one question also in the chat box on the status of SND based acts. What happened to them? Because, but again, like Bihar has taken that decision of repealing the state SND. But what about other states? When there is an ambiguity between SND and the labor courts, what should one follow?
Yeah, I would say there has to be a kind of a analysis, and particularly for our set of clients, what we are doing it or advocating at least is to do that proper analysis of what the state's shops and establishment says, because wherever there's an overlap, and because of that overlap, there might be a beneficial situation coming for the employees in one of the regimes. You follow that regime, and again, what is beneficial is again a big question, and again there is a practical aspect around it. Is I'll give you a very simple example. Now, my OSH code talks about leave encashment provision. It says that the workers will be entitled to leave encashment, and it says that not more than 30 days of earned leaves can be carried forward. Again, no harm in that. But if I look at Shops and Establishment Act, there sometimes the limits are stretched to 45 days, 60 days, or even I think 90 days as well. So now the big question is whether providing a greater accumulated earned leaves is beneficial for the employees or not beneficial. Some may say it is beneficial. I am allowing more leaves to be carried forward. I would defer on that argument. I would say that the contention of the government or the intent of the government was to provide a work-life balance, and that is why they've reduced this limit. Because by and large, the carry forward limit used to be 45-60 days. That has been curtailed to 30 days because the government wants people to start taking leaves. And and the concept of the lapse leave is also something which is no longer there under the OSH code, again relegated to only the worker category of employees. So my view is between the as far as regarding this leave encashment or the accumulation of the leave is concerned, between the choice between 30 and 45, my advice would be to stick with 30 because that is more beneficial in terms of advocating that work-life regime for the employees. Again, there might be differing views, but again, if it comes to that, then again clarity might be needed from the government as to how we need to go about it and how do we need to interpret that which is more beneficial.
One question that's coming to my mind, Anurag, I'm not sure, Jayant, if it has come in the chat box or not, which is on the gratuity payment thing. As of now, what we follow is a 6-month rule. So if it is less than 6 months or more than 6 months, then you consider it to be 1 year. But in the case of FTEs and in case of death of an employee, now they're talking about prorated. So prorated would mean in case it is 3 months, 4 days, then it is 1 year, 3 months, 4 days, or we still have that 6 month thing applicable here?
I think we'll have to go with that analogy only, Monica, because as you rightly highlighted, that is the groundwork that they have laid down as one of the calculation methodologies. What they have simply said it is, but my question here is, and this is a very interesting thing that you have asked. I haven't come across this question in any of the forums, and I might have to go back and again, do that one-to-one reading of that particular thing. But my take around this is that the intention of the government is to provide it on a pro rata basis. The word they have used is pro rata.
It's pro rata, yeah.
So one view could be that if somebody has rendered a service period of 3.5 or 3.6, do I construe it as a 4 years?
Yeah.
Because interestingly, what happens is, and this is again for the knowledge of our, information for our audience, while the gratuity talks about 5 years, that is what is built into a
Yeah.
common logic. But when we
Right.
do that eligibility, we always say whether it is a 5 work week establishment or 6 work week. If it is a 5 work week, we count it as 4 years, 190 days. So 4 years, 190 days becomes 5 years. Right. And if I'm a 6 work week establishment, then 4 year, it becomes 4 year, 240 days as 5 years. So the thing that one needs to see is, in case of a pro rata, if somebody has rendered a service period of 3.6, whether I will construe it as a 4 year or whether I will construe it as a 3.5. My take would be, because that word hinges on that pro rata thing. So I think it should be 3.5 or 3.6 only, because what they are saying is that whatever services you have rendered, we will pay you a gratuity on that basis only. So right now that is my fair guess, but again, as I was telling you earlier, I've never faced this particular question, so I might have to do that one-to-one reading of that particular section. And because now we are connected, I'll surely get back to you on that.
Yeah. I take pride in asking rare questions.
That's good for the audience as well.
Yeah.
Yeah. So before we jump on to the Q&A session, and I know many of, while we have tried to address as many questions, and Monica has been particularly very, very helpful in raising those questions. She's in terms of reading the mind of our participants. But in terms of where do we fall? Where should the organizations go next? So this is a kind of a 4-step process that I've done. Of course, many of the 4-step process would be, you start with the impact study and compensation study, but that has been done and dusted away with. Let's start with, don't wait for the start to start. First and foremost, very, very clear. My recommendation is, don't wait that state rules will come, you have to then we will do that. That is nothing but a procrastination part. I would say start it, because already you might be in a non-compliance regime, or you might say, the common feeling is, it's a new law, government will take its own sweet time. This will not come back to haunt you right now. This will come back to haunt any organization who doesn't follow or comply with it after 2 years, 3 years. That's when the regulators will start becoming more aware, because at the present, and this is again, Jayant, an interesting question that a discussion I was having with one of the regulators. I was telling them that, sir, this is what has come, and many of these changes, not even the regulators at a field level office are even aware, because right now they are so much burdened with their ongoing tasks that they don't have the bandwidth to read the law and try to understand what are the changes. It is only when the government at a senior level, at a board of trustees, or at a at a CPFC level, or any at a commission level, start pushing it for the employees, then in this things will start working out. At a base level, I would say, based on my experience, I haven't seen that much amount of traction that the regulators are even aware that what are the key changes. Because today down the line, if you go at a field office level, be it PF or ESIC, and tell them that so and so changes have come, have you started asking the question, they say we are too much burdened with the existing work, with the regular PF stream, with the Pradhan Mantri Viksit Bharat Rozgar Yojana, with the voluntary disclosure scheme. Their hands are totally full as of now. So again, this will take time, but at the same time, them sleeping is not a clue for us to be sleeping as well. That is my point, because they have the power to start retrospective notices from 21st November, and there is a limitation period. I think there's a 4 to 5 year of limitation period, but that again is a very wide period in that sense. That, let's suppose we talk about T plus 4 years, and an organization receives, then what will be the defense strategy at that point of time? You cannot say that I wasn't aware. So that is the key thing, and that's what we want to say here. Don't wait for the start doing it right now. Map each of your codes governing authority. Try to understand what is your appropriate government and accordingly do that mapping exercise. Big chances are, in case you have a multi-state presence, that you will be having a hybrid rule mechanism wherein your code on social security will be covered under central rules, and the remaining three rules you will have to rely on state rules. Third important point, retest the 50% rule. In case you have formulated, sit with your payroll guys, sit with your knowledgeable people, try to understand that whatever has been done till now, has it been done as per the compliance, or has it been done within that framework of the wages or not. That is another key thing. And last but not the least is track the notifications. You can't be sitting on the only the code and the rules. Start tracking the central as well as the state notification as well, because trust me, there's a lot of changes which are coming every day or the other. Some new notification comes which either levies any kind of a new compliance strategy for the establishment, or provides a certain leeway to the employees as well. So those are the things that one needs to keep in mind as our next steps.
No, I believe one point which you mentioned, that we should keep a track of the regulatory changes, and I believe yeah, more so what's happening right now is that the thoughts are also changing, because you may have started working on the laws with certain thoughts. The political compulsion changes, and at the same time the financial and economic situations are also evolving. What the one point when you mentioned about increasing the wage PF ceiling. I'm saying is, but the problem with right now, you need more fluidity and the cash in the market flowing in the market right now. You can't push people for more savings. You wanted on your leave encashments, or also you want more fluid. You want people to spend more money. Whoever is earning should be spending more on the travel and tourism at the same time. The government has those kind of a compulsion. So I think important is to read those updates, understand how it is impacted, because certain decisions you may take basis what is potentially coming, or you start preparing about it. But when the change scenarios, government may hold or defer those decisions. What you would have been very evident that they are coming to us immediately. That's also one thing. And Anurag, one quick question before we jump onto the Q&A. I think this has been asked by somebody. What is your take on, and Monica, this I would want to come back to you also the same question. What is your take on the settlement within the 2 days of resignation?
So, should I take this or because I know it will be a live issue for Monica as well. So I'll tell you.
Yeah, go ahead.
Yeah, Monica, please go ahead.
So see what we have done practically, because it was just not possible to do it within 2 days from the last working day. So that's why we have started the exit formalities minus 7 days. And we have also restricted, and it is a company to company, industry to industry. We have also restricted the last working day as Friday of any of the weeks, so that there is more time that we have to do it. So Monday to Friday is something that we say that, okay guys, you start working towards your F&F clearances, be it stores, be it finance, be it administration, whatever. And then Friday is the day when you finally submit your assets, you submit these clearances, NOCs, everything. And then we have time by Monday, Tuesday, we are then able to do it. So this is how we do it. And I don't know what is the industry practice though here, but that's what we have started.
Yeah.
But that's a very practical approach, because it is for a large organization. It's virtually not possible that you start preparing for F&F on the last day, and you can achieve it within 2 days. Yeah.
Yeah.
Good
No,
part.
right. I totally agree, Monica, because there is while the law says, and again, this is interesting to note that this settlement timelines is nothing new which has been prescribed under the labor codes. It was there earlier under the Payment of Wages Act. This settlement timeline has already been there. The reason why companies more or less didn't used to comply with it was because the payment of wages was applicable at a particular threshold limit, which was 24,000. Now, because that threshold limit has been removed, so the Payment of Wages Act related, provisions are applicable blanketly across all the employees. So the second important part I wanted to highlight was that yes, that 2 day settlement timeline is there. There was a lot of pushback from the companies. I know that in various trade forums they said that this is practically not possible. At present, the government has not done, or I think provided any clarity on that. There is no clarity needed, but rather you were saying that extend this timeline to a practical sense. Now, first and foremost, they say that the wages has to be settled within that 2 day settlement timeline. What is my wages? That is a very prominent question, because wages is something that you would have considered based on my previous slide, that is my wages. But at the same time, if you look at the proviso that has been built under the wages, they say that for the purpose of the timely payment of wages as well as the equal pay, my wages will include overtime payments. It will include HRA. It will include the conveyance allowance as well. So the government intention is that the organization may say that look, we stick to the definition of wages. So we settle that payment within 2 day settlement timeline, and the remaining payments can be shifted for a later date. At least that's a natural thought process that I was hearing from a couple of companies. But they have ring fenced that entire thing. By adding that proviso, they are saying no. Even conveyance allowance, HRA will be part of inclusion for the purpose of the timely payment of wages. But I would say there are a couple of settlement timelines that you need to keep in mind for wages. And that wages means the expanded definition, including that proviso, is 2 day. For payment of gratuity, it is still 30. It was earlier 30 as well. For leave encashment, wherever there are resignation cases, the leave encashment again has to be settled within 2 days. Wherever the leave encashment has to be paid on retirement, wherever the leave encashment has to be paid on expiry of the employees, there is a good timeline, which is, I believe, is 60 days. So the leave encashment can be in such scenarios, which is death in service and superannuation. In such a case, the leave encashment can be remitted within that 60-day cycle. So this is the kind of, the time limits that are built in. Now, as far as based on our, and this is the input that we are providing to our, clients, but what is the practical side to it? I would say the practical side to it is there are companies who are saying we can do it. And these are primarily companies who doesn't have a remote working model, wherein they say we provide a 2 months notice period. So we will begin that FNF cycle. I think somewhere around within that month, we start putting in those processes in place wherein those clearances are already there on the date of exit. Right. So in case those processes can be put, fastened or accelerated and then put forward, there are set of organizations who are clearly saying we can do it. Our payroll can process it. Okay. The second set of organizations are like yours, Monica, wherein they are saying they might be having a remote working employees. And mind you, for remote working employees, things become a little bit difficult because you cannot give the clearance unless until the asset is on board. Unless until laptops, chargers and all those facilities that you provided to the employees, that has been handed over. And that doesn't get handed over on the last day. Typically on the last day, the employee would be busy with transitioning, and then they will send in and courier it to the respective, HQ or wherever those facilities are there, which will take a 1 week or so. So those organizations saying that right now it might not be practical for them to go with a 2 day settlement timeline. They say, okay, fine, we can't go total non-compliant. So we have stretched it to 10 days. So what they're saying is we have pushed it to 10 days, and then once more clarity comes, or we are able to put forward our policies in a more better way, then we can come to the 2 day. But right now they have stuck to 10 days. Then there are organizations.
It's 5 o'clock.
Then there are organizations who are simply saying it is not practically possible. We'll go with that 30-day or whatever there is, and then whenever that question comes before the authority, we'll try to justify them. So again, a mixed bag. But one interesting aspect, Jayant, and I know it is not related to full and final, but again, a process that I've generally seen is normally when a person or the employee resigns, typically an organization always had that policy that your salary will be put on hold. So nowadays, I've seen many organizations having that 3-month notice policy or 2 months. So typically after finishing 1 month, they put their salary on hold. Unfortunately, what has happened, and that is again my personal take, is that the Payment of Wages Act is strict in a sense that they are saying that the wages has to be remitted and the payment cycle cannot be stretched beyond a period of 30 days. In which case, the interpretation could be then that process of putting the salary on hold might be non-compliant with the chapter on the timely payment of wages. So that is also something that an organization should look at and see how best it can be aligned.
Okay, so just to summarize and paraphrase, Anurag, we are saying here that everything which is forming the part of the wages we should strive to do it within 2 days. And yes, there are exemptions basis the kind of industry and the remote working or work from office is there. However, leave encashment, gratuity are some components that they can take longer time, and that's fine, right?
Yeah.
Okay.
Gratuity clearly 30 days is there. So
Yeah.
which is I think which was there earlier as well. Because
Yeah.
calculation and doing that working takes time.
Yeah.
Leave
Yeah.
encashment, if a person is resigning, then it is 2 days. On superannuation or expiry whilst in service, it is stretched to 60 days.
Okay, got it.
Yeah, Jayant. What are the next questions?
So, I think the questions are coming, more on the same lines what we have already discussed. But they are more specific questions. For example, if a company does not restructure the wage now in the current financial year and plans to implement the compensation restructuring, if need be, in the next financial year, will the company be considered compliant in that case? Which So I'm going to defer it by one year. Now, will I remain compliant?
So it all depends, I would say, because one has to again do that analysis. See, the compliant part will kick in once there is a shortage of the contribution, when there is a short payment. So let's suppose right now you are paying a PF on basic pay, and that basic pay is around 30%. Okay, the law says that minimum wages has to be minimum to minimum 50% based on that conditional inclusion part. In which case, I would say that the organization might be falling in terms of this short payment and again, triggering that particular aspect. Similarly, what has happened in the case of ESIC? So ESIC, based on the erstwhile regime, was being calculated more or less on a gross basis. So people who might have gotten excluded under the erstwhile regime, what we are seeing a trend is that they might get covered as well. So again, then there is a non-compliance. So my advice to the relevant individual would be, and as I was telling in my earlier slide, don't wait. Whatever structuring, whatever you have to do it right now. Don't wait for the next financial year, because again, you won't be having any leeway in case that inspection or that compliance is being done by the the regulators. One key thing I also wanted to reiterate, or I would say put forward, is that the penalties, the fines are many-fold times as compared to the erstwhile regime. So one has to be again very cognizant of that fact that in case there is a non-compliant situation, the penalty is going to be harsher. The prosecution and all those limits are going to be harsher. So it's not only a question of non-compliance, it's also what will be the cost of a non-compliance. That is another important aspect that organizations have to be aware about. So I don't see any valid reason for pushing for the next year, because there might be an impact, and we are seeing those impacts happening across the industries. It is not labor code is not relegated to only factories or coal mines or plantation. It is something that will be impacting every organization through and through. So you can't take your ticket out of it and say, okay, fine, let me do it or push it to the next fiscal year. There's no reason for that.
There is a question from Rohit, on the can we reduce the PF contribution to minimum ceiling limit of 15,000 instead of the actual basic pay while restructuring wage definition as per the new labor code? Rohit, I have shared a link to our previous webinar on the labor code. My request is you could check that out, because we have done a very detailed discussion on this particular question. specifically from 1 hour, 5 minute onwards, you would find almost like a 5-10 minutes of discussion, and we've taken with multiple examples and a couple of slides also. That should help you. I've shared this link here. Okay,
Yeah.
and then there are multiple questions coming back onto the same thing. Would variable pays or allowances, are they part of the wages? Let me summarize in my way and correct me or add wherever you feel. See, anything which is to be paid to an employee, which is a fixed component, uh, which has no variability and aligned to it, is part of the wage. Even if you may call it a variable, but you are paying it on a monthly basis, or even you are paying it on a quarterly basis, but there is no condition attached to it. No organization achievements, no personal achievement, then it's a part of wage. If it is any condition attached to it that you may or may not get that particular component or that amount, and you would only get if certain conditions are met, okay, then it is not part of the wage, because then it's not, that's not a part of the wage, then it is, it is pure variable. Okay, it could be sales incentive, performance bonuses, it could be your variables linked to company performances. It could be annual. And again, Anurag mentioned one point here. You are paying it monthly, or you're paying it at the end of the year. These are two also component. You're saying it's a variable pay attached to the company performance, but I'm paying monthly. No, it's not good. You will not be able to substantiate because you're not looking at the company performance on a monthly basis. Even if you're a listed company, that's least is a quarterly payment. And then also, if you are releasing the payment before the quarterly results are announced, you cannot substantiate that it was related to the company performance. Okay, so those are few aspects I think you'll have to look at while looking at various components which you are paying variable. Anurag, correct? Add any
Absolutely. No, you're bang on point.
No.
And these are the nuances that you need to take care of when you're interpreting that definition.
Yeah, and just one more addition here, that one-time payment, which is either a bonus, joining bonus, or a appreciation bonus, that will be excluded. That Anurag has mentioned. Yeah.
Right. As per the OSHW code and its query, you would appreciate you guys. OSH states that every principal employer is required to register on the Shram Suvidha portal within 2 months from the notification of the rules, which were published on 8th May 2026. Since hotels are already registered under the Shop and Establishment Act, is it still mandatory for hotels to obtain registration under the OSHW code as a principal employer, or does the existing SND registration suffice?
No, I would say it's working in a different way because I see in couple of states, shops and establishment now amending, and those amendments are coming wherein they say if you have got yourself registered under OSH, then there is no requirement to do a separate registration under SNE. But I do think that the reverse would apply. My suggestion would be to stick with the safer approach of getting your organization registered under the OSH code registration again. Again, because and I believe that the person who has asked this question, that the central rules might be applicable, because this time limit will start from that particular date when the central rules have been notified. In case the state related rules are applicable, then you wait for those state rules to get notified in order to do or initiate those registration.
How ESI need to be calculated based on code on wages? Since the term wages is changed, what other components needs to be considered?
It's the same. I think it's the same as the uniform definition of wages. Yeah. I think most of the questions we have covered. One question I think interesting is around the overtime part, because again, this is something that is impacting majority of the companies. So, I mean, Monica, in your practical experience, are you seeing that companies are now, revising the policy? I know for blue collar worker, traditionally companies used to have this overtime policy, but there was an interpretation, and particularly more so the kind of language which was there under the code on wages, as a result of which one view that is coming up is now that even the white collared employees will be entitled to overtime at double the rate of wages. But are you seeing any kind of industry trend, or any positions that can be forming up there?
Yeah, interesting that you're asking this, Anurag. One, we are a media company, so it's 24/7. So not really sure from where the day starts and where it ends. However, one, I think the base and the critical thing here is to categorize your employees, as I've said earlier, that who's a worker and who's an employee. Because, for example, in our case, a working journalist, irrespective of whatever level he's working, so a working journalist is a worker, audiovisual person is a worker, and overtime needs to be paid, to such employees. So it starts with the basics, which is the categorization, and then looking at the policy of overtime.
Hmm. Right. I think because I'll tell you the reason why, and while your the interpretation is correct, I think the confusion which is coming up is because there are two separate regimes talking about overtime. OSS talks about overtime for worker category of employees, and the limit is overtime at double the rate of wages. What is by
Yeah.
overtime is anybody working beyond the 48 hours. The central rules have notified 144 hours of overtime working within a quarter as the upper limit. Whilst the code on wages also talks about overtime, it says that any person whose wages are fixed under the minimum wage criteria will be entitled to overtime, and that is where you know the confusion is cropping up, wherein because by minimum wages earlier was being paid on scheduled employment, but now it will be paid to every employee. So now the question which has come up is whether even the white collared employees will be entitled to overtime, in which case I would say again multiple views are there. Some are saying that yes, it will be applicable to white collared employees. My personal take is it might not be so. The reason for that is that if the relevant state has prescribed a minimum wage, and if I'm already paying more than that, then obviously I'm not paying them the minimum wage. I'm paying something which is under the employment agreement. And I think in one of the FAQs, the government has also tried to draw a distinction between what is the minimum wages and normal wages. Normal wages is what you agree as per the employment agreement. So I think the thought process behind this is to pay overtime to only those people who are being paid minimum wages, and not those who might be covered under the minimum wage criteria but not being paid minimum wages, rather more than that what they are getting. At least that's my personal take, is again based on the past judicial ruling. But again, this is something that requires a considered view. That is something any organization who want to take a particular position, my suggestion is always to document entire thing, take a proper valid legal opinion, and then move forward with that particular position. So I know there are many questions, Jayant, and obviously, like in our past forum as well, we might not be able to answer all of them, but for all our participants, our contact details and every other things will be, circulated in the next slide. So have a look at it. In case you want to contact me, Jayant, Monica, connect with us and raise your
Yeah.
queries, and we'll be happy to address the same.
Just want to add one thing before we wrap up. So, in my experience and the personal journey of implementing the different codes, having a partner always helps. Instead of you doing it all by yourself versus having someone to, maybe an SME, right? Maybe a Anurag, maybe a Giant, it always helps. You should always err to the right side of compliance, and not otherwise. And so while it depends on you how you want to implement it, but that is from my personal experience. I'm saying that go for a partner, guys. I mean, don't try and do it all by yourself.
Thanks, Monica. So we've never made a sales pitch, you right, Jen?
Okay, you should pay me for this then.
But I want to clarify that's not a paid comment, from Monica.
Nothing from us.
Yeah, definitely, guys. So I agree to this thing. They've not paid me for saying this, but honestly, from my heart, I'm saying that looking at the kind of confusions, and it is not a joke. It is really not a joke. It was very difficult how you decipher, how you move forward. And we being a listed organization, it was not easy for us. So having a partner, on your side always helps, and try and do that is what I can recommend to everyone.
No, no, absolutely. And this is our thought process. Same. It's not something that, of course, we are a part of a service industry. But what I have seen is that it helps a lot because clients might not have the time, because in your normal, in your normal business activities or whatever, part of organizations you are, or part of the verticals, you won't be getting that much amount of time in trying to
Yeah.
decipher the law and interpret it. And because this is not a one legislation, we are talking about the consolidation exercise for 29 central labor
Yeah.
legislations
True.
with, so there are a lot of moving parts. As a result of which, it always makes sense that you have multiple minds who are approaching it. There might be multiple views, and it's good to have all those brainstorming, and then arrive at a considered decision around it. Otherwise, few years down the line, you would have said we could have done better around this implementation.
Yeah, because the cost of non-compliance can be huge. So that's
Absolutely.
why people should tread with caution here.
Yeah, yeah.
Okay.
And also, I believe with any external consultant, they also bring a lot of industry know-how also, how it is
Absolutely.
being, and they would have possibly learned from the mistake, because that's my personal opinion. I would say I've been on this side of the table where we are providing advisory and consulting. Not that we get it right on the first go. We also learn from a lot of mistakes which which others have done. But only advantage with us is we would have spoken to 100 people and understood their mistakes, right? You as you as somebody working within an organization may not be exposed to so many mistakes, because people will not come back to you and tell you about their mistakes. So you would have to do this mistake to get the learning. We would have learned it from on others' expense, and that's how we would any consultant, I'm saying, is from the fraternity, would possibly benefit from you. Now, coming on the last, I think there are a lot of questions which are coming, but these are very specific. There is question around the price calculation on ESIC. Then there are questions around whether the company should pay me the incentives or variables for the last year, or the gratuity. I would want to defer onto these comments. Or rather, I would not want to comment on this open forum. Feel free to question, raise your queries to us, and we will try and address if it is within the ambit. Second, my recommendation, please, and I've shared one link to our previous webinar. We've done multiple sessions on the labor codes, and as I said, this is not something which can be addressed in a webinar of 1.5 hours. We typically do 1 hour, but this time it's almost 2 hours right now. This is something where you need possibly days of discussions. For any client, we do a 1 hour, one full day session talking about various codes. Please look at all the various webinars. There are multiple pointers which are very, very important to understand the labor codes, which we have addressed there. The videos links are available on our YouTube channel. Himashi has already shared the link. The link is also there in the comment section which I've shared. Feel free to watch there. And then if you still want to talk about, reach out to us, our Anurag's email ID, contact us at bythebook.co.in. You can reach out to us info@orbit.com. Feel free, and this is the number you can also connect with us. Thank you so much. Again, I believe there's a lot not covered still. But as I said, it's a labor code. No matter how much you speak, you still feel there are still questions unaddressed. We'll try and address it in a few future sessions. And thank you so much, everyone, for staying back for almost 2 hours for this discussion today. And Monica, thank you for being here, because you're as I told you yesterday, the way your articulation about the problem statement is far different and better than us, because I think people are able to resonate and relate better with the way you are asking those questions. Thank you for bringing this perspective. It really helped.
No, it's my pleasure. I thoroughly enjoyed the session, honestly, Jayant, and thank you for this. Thank you, Jayant, and thank you, Anurag. It was lovely.
Thank you so much. Thanks, Anurag.